Laura. Really interesting chat and a number of really good questions tossed into the chat boxes. Interestingly, they follow the structure of your talk. So the first two are questions about who the framers feared in terms of adding the Bill of Rights to the Constitution. And in particular, there's no FBI, no CIA, no ATF, ICE, DEA, IRS. None of these institutions, these executive agencies existed. So who did they fear? That's one part of this. And then the second part of this is the debate over fundamental rights and Madison's initial opposition to including a Bill of Rights. So two sides of a coin. Who were they afraid of? Who were the Anti-Federalists afraid of, and why? And how did Madison approach this question initially?
Good question. So with respect to the first part of that, I think, again, Joe makes a good point. The government, the federal government, is a shriveled husk of what we sort of see today, right? There's not this huge administrative state that that we have all lived with for our whole lives. And the ratification debates, obviously the Anti-Federalists felt one way and, the Federalists felt a different way about strong centralized power. And we're coming out of the Articles of Confederation, right? Where there were struggles with coordination, there was need for sort of decisive action to be taken. So, I think in terms of who the Anti-Federalists, were afraid of, I think it's more kind of like federal power, like generally, right? So they're afraid of Congress. They're afraid of a strong executive. And look, this is a legitimate concern, right? Given our country's history, like what we've just come out of. So this is really about whether states and the structures that existed were going to be kind of withered away. They would be deprived of resources. The federal government could do things like tax, and they could enforce that taxation, so they could collect money. And so this is about kind of, I think, more about like levels of government. That's my sense of it. I'm not a historian, I'm a political scientist, but that's how I would sort of read it. With respect to the question about Madison, I don't actually know the answer to that. And I wonder, Joe, if you have thoughts about that.
Yeah, I think, and in fact, to emphasize your point about the Bill of Rights being a reaction to what they knew at the time, a good question to ask students in class is, why do you have a Third Amendment? It protects against quartering troops in homes. That's not been done for a long time. But the folks at the time of the writing of the Constitution had very fresh in their mind British imperial policy. And a lot of this is limits on the executive, quite honestly, at least in the general sense. They had a real sense of the danger of having the government make you keep soldiers, because it makes the cost of maintaining an army much cheaper for the government. So again, that's a great example of how the Bill of Rights exists in a context. A lot of students think that the Bill of Rights and the Constitution fell from the armpits of the gods, and they didn't. They came out of certain historical context. Now, Madison initially, and Hamilton never came around. Madison and Hamilton in the Federalist Papers, and if you want a Federalist Paper cite for this, it's 84. Argued that there's no reason to have a Bill of Rights because the Constitution itself is a Bill of Rights. And since it specifically limits the power of government, or defines, they argue, the power of government, there's no reason to have specific rights. And one of the they go through 4 different dangers. One of the dangers is if you list a Bill of Rights, then people will think those are the only rights you have, that the list is exhaustive. And that was a concern for them. Now, Madison eventually comes around, and largely trying to buy acceptance for the Constitution once it's ratified, because it's ratified without a Bill of Rights. The Bill of Rights is, in fact, a tack on. But Madison came around to the need, or the utility at least, of ratifying a Bill of Rights, because he thought that would make the anti-federalists more comfortable with the new government. And so for a political reason, to help get buy-in to the new constitution, and again, students think that, of course, this was destined to work. It's still around. And the answer was, at that time, they didn't think it was going to work. At least they weren't sure it was going to work. And so Madison thought, here's just a bone we'll toss to the anti-federalists. It can't hurt, and maybe it will help.
Great. Thank you. That was great.
All right. So a couple of, let's see here. Question from Manuela. How does the state or federal government infringe on fundamental rights?
Great question. Thank you for answering that. It's a really abstract way to frame it. So they might infringe on a fundamental right by restricting your freedom of speech. They might infringe on a fundamental right by limiting your ability to practice your religion. They might infringe on a fundamental right by, as we'll talk about a little bit later, making it illegal for there to be interracial marriage, right? So when we say infringe, that's the kind of, so laws that are like regulating those things that are fundamental, that's what we mean. A lot of this is, of course, like when people are bringing lawsuits, they're framing this in this particular way. So it doesn't mean that the federal government can't do anything to regulate around a fundamental right. That's not true. But they are way more limited in the kinds of things they can do if a right is considered to be fundamental than if it's just considered to be a plain old vanilla right. And that's why it's so important, this argument about whether something that's not written even in the Constitution, whether it's fundamental or not, because it just really limits the kinds of things that the government, that either level of government can really pass that that addresses that particular issue. I hope that answers your question. It's a really good question.
All right, there are two other questions, and I'm combining questions from peeps here. One is, and this speaks to how do we know what fundamental rights are? Why doesn't the Fifth or the Ninth Amendment get used more often? And how does it fit into this general discussion? And then the follow-up off of this, and this comes from the very end of your presentation, is how do you keep the court from going too far? Assuming that it's going to have judicial review and it's going to provide this sort of checking function on other branches of government, how do you keep it from going too far?
Great. Well, so with respect to the Ninth Amendment first, the Ninth Amendment is sort of, you know, like kind of a forgotten amendment in the Bill of Rights. It doesn't get a lot of the same attention that a lot of the other amendments get, but it's about the rights reserved to the people. And there are definitely people who take a strong position that like this is the natural repository for things like the right to privacy, right? That this kind of makes sense, that there are some things that we always had. We had them before the Constitution. We retain those rights even once we kind of, as Joe kind of described, right? We lay out the specific things that are in the Bill of Rights. Justice Stewart, who's one of the justices in the majority in Griswold versus Connecticut, makes this argument that it's about the Ninth Amendment, that's where the right of privacy is. But nobody else really gets on board with that. There's a dissent that criticizes it, that says that like basically the Ninth Amendment is just kind of a truism. There's not any meat there. And so it really hasn't really gotten a lot of traction compared to the due process clause. That is where a lot, you know, like most of the action is really kind of happening. So with respect to the penumbra theory about privacy, one of the rights that is like listed in that penumbra, so the collection of provisions in the Bill of Rights that suggests there's a right of privacy, one of those is the Ninth Amendment. So there are justices that kind of see it as something that maybe kind of bolsters their argument somewhere else. And you'll see litigants who still use it, but there isn't anything that's very kind of specifically identified out of it that has really ever kind of taken hold in constitutional jurisprudence. So, so that's my answer to that part of the question. And then the second question was about how do you keep judges from going too far? And I think that is the million-dollar question, right? So when the court says, here's our criteria for fundamental rights, they've got to be implicit in a concept of order and liberty, and they've got to be deeply rooted in the nation's history and traditions. That is their attempt to put some guardrails on so that when Justice Laura sits on the Supreme Court, she doesn't just get to put in place any fundamental right that she feels like should be there. But of course, those guardrails are not incredibly constraining, and different justices will apply those same criteria and come to opposite conclusions about what is fundamental. And so there are some places where there is consensus, and you'll find that with your student. You'll find some places where there is consensus. But this is part of the reason why it's important to look at the kinds of questions that justices are asked in confirmation hearings, right? Because we get a sense for how they see the role of the court. Do they see the role of the court as kind of continuing to kind of expand freedom? Or do they see the court as a more limited institution that decides that, you know what, if you want a new right, amend the Constitution and put it there, right? Those are sort of like two opposing views. So the main check that we have on that discretion is actually electing presidents and senators, because we can't do anything directly with respect to Supreme Court justices. So that's a great question. And that is part of what we argue about every single time there's a vacancy on the Supreme Court.
There's so many other questions that could spin out of this, but we have to pivot now to your documents.